So that was one of my knocks on field training was, hey, you do great in high stress situations. You gotta calm down when you talk to the regular public. So I do miss it somewhat. If that answers.
Okay.
Well, since you're on that, what do you prefer, the street or being in the jail?
Me personally, I prefer the streets.
Streets, okay.
I think that it gave me a sense of, not a sense of being, but more, it allowed me to change who I was, right? I did 4 years active duty in the Navy, a year in Guantanamo Bay where I was dealing with high value detainees, right? We're talking about people that were responsible for 9/11, terrorists, a bunch of other people's sympathetic people to Al Qaeda or ISIS, right? So that made me very hardened. Then I go to the jails and I'm very hardened, right? Then I get to go back out to the streets and I talk to normal people. So it was a good transition for me. I prefer the streets. I obviously did a lot of time in traffic. I did 7 years in total of my law enforcement career has been done in traffic. And I did a lot with major injury and fatal collisions. It's something that I learned to really love because what you can find out in traffic is really that a traffic collision is physics. I know a lot of people in high school, college. I didn't want to do math in high school. That wasn't sexy. It wasn't what I was interested in. But when I got into traffic, what I learned is that applied mathematics is a lot more fun than written mathematics. So when you can actually apply it and learn that, hey, this skid goes this way, and this car has this much crush, and you can put all these little mathematical figures together, all the formulas, and come out with this car was traveling this direction at this speed, this car was traveling this direction at this speed, this is exactly how the crash happened. It's actually very interesting to see. So. And I thank you for calling me young earlier. I appreciate that. I'm starting to not feel that anymore, so the body's catching up with me.
Yeah.
Today, obviously, we're going to be talking about defenses. Excuses and justifications is the main, and I threw in insanity as an extra there because we'll talk a little bit more detail about insanity. We already went over the introduction. I'm going to skip over all of that. So first, I'm going to give you guys a scenario. This is a real scenario that I went through. Imagine that you arrive on a scene, you walk into a house, and you go, as soon as you walk in, to your left is a bedroom, and in that bedroom is a female victim on the ground with multiple stab wounds and one to her neck. Blood throughout the room. And then you look over to the right, and there's a man standing near the window, angry, stoic, just kind of upset, nonverbal, doesn't want to talk to you guys, doesn't want to interact, no movement at all. He has a history of drug use and schizophrenia. And then some of the questions we have to think about on scene, not just, hey, how do I control the scene? What happened here? How do I solve this crime? But what defense is this guy going to use? What can I do right now that's going to figure out how to either A, clear this person of a possible murder, or ensure that I get a conviction and justice is served? Keep that in mind as we go through a lot of this stuff, and then I'm going to explain a little bit more detail later on of what happened that day. So some key legal concepts and definitions we're going to go over are excuses and justifications, including duress, mistakes of fact and mistake of law, mental incompetency versus insanity, diminished capacity, competency to stand trial, and civil commitment. So excuses versus justifications. What are some excuses that you guys can think of, or give me an example of what an excuse is?
I was drunk.
Drunk? Okay. Anybody else?
Not alert.
What's that?
Not alert.
Not alert. Could be, right? So what I did was wrong, but I'm not to blame, right? That's an excuse. So when we talk about an excuse, you knew that the act that you did was wrong, right? But you're saying that because of my mental state, right? I was drunk, maybe. My schizophrenia or something caused me to do this, right? That I can't be blamed for that. One of those things is duress, right? Another mistake of fact in law. We'll go into these a little bit deeper. Insanity, diminished capacity. And then for justifications, it's more along the lines of what I did was right under the circumstances that were given. And what that can look like is self-defense and defense of others, and a crime of necessity. So for duress, one of the case laws that we look at is Dixon versus United States. It's a 2003 case in Texas, where a female ended up purchasing weapons for a known convicted felon, her partner. And the reason she did it was he actually told her that if you don't purchase these weapons for me, I'm going to kill you and your 3 daughters. Right? So she's under duress. This person's telling her, you have to do this for me or else I'm going to kill you. Right? There is no immediate violence. He's not holding a gun to her head. He's not actively stabbing her or anything like that. But he is telling her, if you don't do this, something else is going to happen. So now she's under that duress. She buys these weapons. She actually gets arrested for that crime. She goes and she successfully argues that there's a pattern of abuse. Talks about the battered woman syndrome. I don't know if you guys covered that or not.
Not yet.
And then what that does is the duress defense negates the mens rea. You guys spoke about that earlier. And then a mistake of fact or mistake of law. Right? Two different kind of things. A mistake of fact occurs when somebody says, like, yeah, I took that purse, or I took that gray backpack there. I walk over and, class ends, I grab the backpack and I head out, right? But I also have a gray backpack, and it looks exactly like that. So I thought that was mine. So I'm gonna go over, I grab the backpack and I head out. Okay, cool. Well, then come to find out on camera, my backpack was actually on the other side of the desk. That's a mistake of fact. I thought that it was one thing, but it was another. And then we'll talk about how to either justify that or how to make a defense to that in a little bit as well. Then a mistake of law is something like, I didn't know that was illegal. And most of the time, that's not going to be a valid defense, right? I didn't know that murdering somebody was illegal. I'm sorry, like, everybody in the world should know that murder is not legal, right? However, there's certain times, especially street police officers, like, you may not know everything is legal. Who in here knew that having sunglasses or glasses on with a bridge width right here on the side of your eye over a half inch is illegal to drive with? Anybody? It is.
What?
But I bet you didn't know that. So that's why, I say that sometimes mistake of law can be justifiable, right? Can you still get a ticket for it? Yeah, you could, right? But does that mean, like, if I pull you over and you're like, yeah, I had no idea that my designer glasses that I paid $500 for were illegal for me to wear while driving? Right? Okay, well, hey, just don't do it again. Take those off. Right? We'll let you go. Yeah.
May I ask why?
Why?
Why the inch brim glasses are illegal?
Yeah. So imagine you're driving down the street. You're looking out your windshield here, and somebody starts walking from this side. That bridge of your glasses right here blocks your view of that person walking, right? Until they get to a certain point.
Mm.
So that's the reason why those are illegal while
Okay.
driving.
That makes sense.
Yeah. Just to make sure that you can see the pedestrians coming or cross traffic or something like that.
Okay.
It's the same reason for tinted windows. Everybody thinks, oh, well, tinted windows are illegal just because they don't want, because they want to see in my car so they can see me on my cell phone, right? No, that's not the reason. I've actually been to those crashes at night where I've seen that this person has very dark tinted windows, and they didn't see the person literally. I'm telling you a real case. They didn't see the person in the wheelchair coming across the street, struck and killed the handicapped person in the wheelchair. All because their windows were tinted. So, sometimes those things, and again, then that person is going to claim a defensive mistake of law, right? I didn't know that having my windows tinted on the side was illegal. That doesn't excuse that, right? You should have reasonably known that. The next excuse is insanity. And this is kind of a bigger topic that we'll talk about a little bit. Anybody familiar with the Monotone rule? So the Monotone rule was an 1843 case in England where Monotone actually killed the prime minister, right? During his trial, the defense actually said that, hey, he believed that he had to kill the prime minister because somebody was telling him to do it, right? And they presented a defense that, and brought in their expert witnesses that said, yeah, he's clinically insane. Right? So the jury in that case actually said, yes, he was found not guilty by reason of insanity, and then he spent the rest of his life in a mental institution. The finding of insanity isn't made by the psychiatrist, it's not made by the psychologist. They're there as expert witnesses. What they do is they're going to go in, they're going to testify to that, and then the jury is actually going to decide whether or not they provided enough evidence to show that this person is clinically insane and should be put on a involuntary committal. The finding of insanity may relieve a person of criminal liability, but they can still be held for that treatment. I think I have the next slide. Yeah, we'll talk about that in a minute. So the difference between insanity and competency to stand trial. Insanity focuses on the mental state of somebody at the time the crime was committed. Right? Were they able to know right from wrong? Were they able to appreciate the act that they committed? And I don't mean appreciate to be like, oh yeah, they're sadistic and they committed murder and they appreciate that, right? It's just, did they know the gravity of the situation that was happening at that moment? And then competency to stand trial it's a focus on the mental state of the person at the time of the trial. Are they able to assist with their own defense? And the difference between insanity and competency to stand trial is insanity is determined by the jury, competency to stand trial is determined by the judge. So the judge is going to hear this beforehand and say, you know what, this person needs extra mental care prior to being able to come in and stand trial, whether that's therapy, medication, what have you, to ensure that they're able to help provide their own defense. So the defense attorney is going to come in and say, hey, this person isn't able to stand trial. I had a case where we got in a fight with a guy who had been on the streets. He's schizophrenic. He'd been using drugs since he was 17 years old, and as he goes through life and everything, he's not there. He doesn't know what's going on. He has diminished mental capabilities to the fact that he is out committing these crimes. He thinks that he's somebody he's not. We end up getting in a fight with him. He injures one of my partners. We end up still arresting him because the crime still happened. We don't, as officers, we don't determine if a person is mentally capable of committing the crime in the field. We're still going to arrest for that, and then what we will do is we'll help prepare a case to show whether they're insane, whether they're competent, or anything else. And then from there, what happened was the judge said, hey, listen, this person right here, they're not able to stand trial because they can't help in their own defense. So that person went to a mental institution for about 6 months. They were put on medications, which actually helped them out with their schizophrenia. Turns out once he was clean of all drugs and he was under medication consistently, he kind of started coming back too, and he realized, you know, hey, he didn't remember any of his time on the streets. I think at the time he was 28 years old, so probably 9 years of drug use, and he didn't remember anything of his time being on the streets. But once he cleaned up, he found out that, you know, hey, he did all these crimes and everything, still didn't know what he did, but he was able to stand trial for it. So what it talks about is, or what it discusses is, can they understand the legal proceedings that are going on? And then one of the court cases that involves this is Dusky versus the United States, where the defendant, it states that the defendant must have sufficient present ability to consult with their lawyer with a reasonable degree of rational understanding. That's very important, the sufficient present ability to consult with their lawyer. If this person is not all mentally there and they can't tell their lawyer what happened or didn't happen, they can't contribute to their own defense. Does that make sense? All right. And then civil commitment. What does it mean for that civil commitment? If somebody is deemed not guilty by reason of insanity, or they can't stand trial, they're not competent to stand trial, they have to be committed. They have to go to a mental health institution so they can receive that treatment. A civil commitment is executed either when they're not guilty or not guilty by reason of insanity, or that they can't stand the trial. And it can last indefinitely, but it's not unlimited. They can't just say, hey, you know what, you're insane, you're gonna go get locked away for the rest of your life, right? Not like in the Monopoly rule. What happens now is that the court is going to go over this multiple times throughout the course to determine whether or not their mental stability has been maintained or not. So if they're still a danger to themselves or a danger to others, they're going to be held. And as far as the competency, they're going to be held until they're deemed competent to stand trial. So then what's a justification? Like we talked about, a justification can be self-defense, defense of others, or a crime of necessity. People v. Humphrey, Humphrey claimed that self-defense when she killed her partner, right? This case happened when Humphrey was battered over multiple years. There were documented domestic violence cases, and then the court ended up acquitting the defendant of first-degree murder, but then instructed the jury to still look at second-degree murder, voluntary manslaughter, involuntary manslaughter, and self-defense. The jury ended up finding the defendant guilty of voluntary manslaughter based on the imperfect defense. So the imperfect defense, essentially what they're saying is, yes, you defended yourself because of everything that has happened in the past, but there was no act happening right now, right? You weren't being threatened with a knife, you weren't being threatened with a gun, you weren't being beaten at that time. However, she felt that she was stuck in this situation and she was getting beat, so she had to react. She ended up killing him. She actually made several statements that he deserved it, right? He deserved it because of the actions he did, right? Now, was she defending herself against future acts of violence, against future domestic violence? Yeah, she was. But it's an imperfect defense because there was no actual act at that time. And that's what's needed for that perfect defense. So a crime of necessity. Crime of necessity is to prevent injury to self or somebody else. There's no other reasonable alternative to that crime. You didn't create a greater danger by committing the crime that you did. You believed that it was necessary to prevent a worse crime, and the act didn't substantially contribute to the emergency, right? Say I'm camping out in the woods and I come across, you know, a small town or something, and it's freezing cold. My tent blew away during the day. I don't have anything to keep me warm at night. And I go and I break into a cabin, right, to stay warm because it's, you know, sub-zero temperatures and I'm gonna die at night if I don't. Right? That can be kind of considered a crime of necessity where, yeah, I broke into somebody else's residence, broke into a house to stay warm, or else I would have died, right? So something like that can be that crime of necessity. All right, so going back to my case earlier where I mentioned, you know, going into the house, the stabbing victim is off to the left, you have the suspect off to the right. As we walk in and we see this guy standing there very stoic, actually I'll step back. Before we walk in, our officers start walking up on the residence and he looks and he says, you're not needed here, go away. Okay? So we had got called there for a medical assist call, and then also there were multiple calls to 911 prior to that as well. So we know that, hey, you know, something happened in this area, we're just not sure where. And then we have this guy who's very angry, who's telling us we're not needed, go away. As we approach, we see the victim down, we see him over there. We end up going in, detaining him. We find out that stored away somewhere is the murder weapon where the blade was actually wiped clean. There was still blood on it, but the blade of it was wiped clean. We started looking into his prior contacts that we've had for his schizophrenia, for him beating up a neighbor, family interviews that we've had. We start writing search warrants for his medical records, and we start writing the report. We talk about the demeanor, his tone, what was he aware of what was going on, right? And what we're trying to do in that instance is we're trying to build a case, not just, you know, is this person guilty of this crime? We kind of essentially know that this person's guilty of the crime. I forgot to mention, we find some blood on his clothes as well. So we know that he's there when she ends up passing away because of the blood. Either that or he goes to help her. We get fingerprints on the knife, everything checks out, hey, yes, this guy did this. But we have to now build our case of either was this, you know, was he clinically insane at the time, or not, I'm sorry, not build our case to say if he was clinically insane, but either protect against that defense or justify that defense. And what we end up doing is we start talking about all the times that we've talked to him prior. He's very clean, he's neat, his clothing is pressed, he's not disheveled, he doesn't have this transient smell or anything like that. And then we start writing that into our report. We use exact statements. Right? What is he saying at the time of the killing? What was he saying prior? Is he making sense? Is he making nonsensical statements? The demeanor that he has, his emotional state. Again, we just talked about the appearance hygiene. Witnesses and family observations. We've been called to that place before where the family members have made mention that, yeah, he's schizophrenic, but he's very high functioning. He actually has a job. And at his job, he makes it on time every day. There's no disciplinary issues at the job itself, right? So all of these go into play to determine whether or not this person is going to be able to use a defense of insanity or not. Again, it's not our job to sit there and say that this person is or isn't insane. It's just to build this case. To tell you the truth, we don't have an outcome of it yet. It's still going on, still going to trial and everything, and it is coming out that he is going to try and use the insanity defense. So it's going to be interesting to see in the next probably 6 months to a year whether or not that's going to happen. So. We also coordinate with prosecutors and clinicians. We share objective evidence, not subjective, right? I don't want to go to a place and say, oh, well, you know what, hey, this guy made these weird statements, so I think he's insane, right? That's subjective. That's my opinion on it. I want to share objective facts of what we find at the location. Avoid medical conclusions. I'm not a doctor. I've never been to medical school, so I'm not going to make those medical conclusions. We anticipate the defense strategies and we build a comprehensive case for the DA. In summary, early recognition and documentation matter. If we can go on scene and we can say, hey, look, like this is possibly what they're going to try and defend against in trial, we can then build a better case, right? And the officer's role is objective documentation. We're truth seekers, we're not judges. I care just as much about getting an innocent person out of jail or preventing them from going to jail than putting a guilty person behind bars, because I don't want to put somebody behind bars that doesn't deserve to be there. So if we anticipate those defenses, it strengthens justice. And then the leadership on scene from your supervisors ensures quality investigations. Any questions?
He's that good. Nobody has a question. I did have, you mentioned on one of your slides about documentation, something about report writing, but I don't know if you want to go back a couple of slides. The way you wrote it, one more, I think. Search warrants, careful report writing, demeanor, tone, awareness. How important is that as far as all these other things in your slide there?
Report writing is extremely important. It's not just what the filing DA is going to look at to say, hey, yeah, we may file on this, we may not file. It's what your deputy district attorney is going to look at as far as what questions they're going to ask you during trial. It's what the defense attorney is going to look at. How am I going to attack this officer in trial, right? And I say attack because that's what's going to happen. For those of you who are going to pursue a career in law enforcement and you get ready to go on that stand, be prepared because you're going to be attacked by the defense. Go ahead.
I have a question. It is somewhat related, but not entirely. How many asylums do you think are still open in U.S.? Because
I would not be able to tell you. I know our closest one is Patton State Hospital. Outside of that, I couldn't tell you how many are
Yeah, we use the Tascadero.
Tascadero as well.
Yeah, we use the Tascadero, and I know there's another one up in Napa Valley. Now we have some state hospitals too for the civil commitments. That can be used for overflow of these stuff, but no, I have no idea. State or statewide, there's a handful. Nationally, God only knows.
Yeah. Statewide, I believe there's probably maybe 15.
Okay. Yeah.
Maybe a little less, but then they also will be transported to different facilities. It depends on the level of care that they need and depends on what that facility has for them. Patton State Hospital is one of the larger ones, Atascadero as well, where they will house for just about anything. A lot of your ones that are claiming insanity, at least when I was working San Bernardino County, that was where everybody was headed, was back there.
They're out there, guys.
Oh, yeah.
Yeah, they're out there.
Going back to the report writing, again, report writing is not just about what the DA is going to look at and what the defense is going to look at. Your report is what's going to be used for you on the stand, right? It's for your recollection. If you don't write it, it didn't happen. That's very, very important to remember, is if you didn't put it on paper, don't expect to be able to go up on the stand and say, hey, this is what happened, because your DA is not going to be able to defend you on it. You're going to open it up for the defense to now attack you on more things. So make sure that everything you document, when you walk on scene, what does it smell like, right? What do you see? What do you hear? What was the call for service?
Touch, feel, all your
Everything.
senses. Yeah.
Everything is very important. When I do a DUI report, I talk about, were they swerving within their lane? Were they swerving outside of their lane? Did they hit a curb when they pulled over? Were they slow to pull over? Were they slow to react? Did they react too fast? When they pulled over and I asked for their license, did they hand me their license or their debit card? Right? Did they have an odor of alcohol emitting from the person, from the inside of the vehicle? Right? All of those things go into a DUI report, and you're going to start documenting everything. When they get out of the car, did they use the door jamb to help them stand up? Were they slurring their words? Did they have red, watery eyes? What did I see? What did I feel? What did I hear? Right? All of those things are extremely, extremely important. And if your DA is not seeing that in your report, remember, they're not going to know to ask you those questions when you get up on the stage. Did you have questions?
Yeah, so for the battery warning syndrome, so, is it because it like pre-planned it? Is that why? Cause like, what if like the husband or whatever said like, you know, next week if you don't do this, I'm gonna kill you. And so she just takes action and, you know, does it. Is that like, is it still like first degree murder even though past like the abuse and stuff? Like,
No, so
what is
in-
it protecting?
Yeah.
Like you said, like future self. And he actually said, I'm actually gonna do something. Is this like I'm so confused on that a little?
Yeah, and then it's definitely kind of a gray area when you talk about future actions, right? Present actions versus future actions is where you want to break it down. If it's a present action, if he says, I'm going to kill you right now, right? I'm going to kill you, he's angry. Now it's self-defense, right? You believe that you are in danger at that point. But if he says, you know what, when I get home next week, I'm gonna kill you. Well, now you have a week to either plan, you have a week to go to the police, you have a week to get out of that situation, right? Where then it becomes maybe not premeditated, but something to where you don't have that perfect defense as far as like self-defense, if that makes sense.
Okay.
So essentially it's time frame. It's either, are you in danger right now, or are you in danger in the future?
And it's also like, what if she wasn't like in the right like headspace? Because I know you were talking about like mental health too, like that takes an effect on it. Would that also like, you know, like help her defense as well, or like would it still because she like premeditated it? Like it's still.
Yeah, so it still goes into not a justification, it's still an excuse, right? The justification is what I did was right because I had to do it, I had no other choice to do it, right? But if you can say at any point you had a choice, then it becomes an excuse instead of a justification. Excuses can get rid of some criminal or all criminal liability depending on what it is, but it doesn't mean that you get off scot-free, right? So say, what's your name, sir? Patrick. Say Patrick, you know, he comes up and we get in a fight in the parking lot out here after class, you know, because I broke his glasses on accident, right? So he goes out, he lumps me up a few times out in the parking lot. And then, you know, I go home, I go to the hospital, I get patched up, and I'm like, you know what, that Patrick, man, like he did this to me. And Patrick texts me like, hi, he's laughing at me, he's like, you're gonna get it next week too, right? So then I go hunt Patrick out, and I find him, and then I beat the crap out of him before he can beat me up, right? Similar situation, you just take out the battered woman syndrome, right? I premeditated that. I went out, I looked for him, I created the situation. Now, my excuse is that he told me he was going to do it to me. He told me he was going to kill me. He told me this. He told me that. So I went out and I did it to him before he could do it to me. Right? It's still an excuse, and in that situation, I probably wouldn't have any real justifiable excuse to get out of criminal liability. But in the court's eyes, that battered woman syndrome is definitely much higher as an excuse to get out of criminal liability.
Yeah, Cindy, at one point you're mitigating the punishment with the excuses, depending on what the jury wants to believe and find credible. Instead of throwing the book, they might find or reduce a charge and do something a little less, as opposed to something more aggravated.
But I was just thinking, like, what if he did it out of fear or something?
Yeah.
Yeah.
It's
And
complicated.
It's immediate fear, right?
Yeah.
So if you can justify immediate fear for your life, then yes, you can claim the self-defense justification versus the excuse.
Oh, thank you.
Yeah.
Good question. Anything else, guys? I just wanted to touch on the report writing. If some of you have report writing this semester, man, it's so important, it's critical that you know how to prepare a good report. And I did want to touch about, you mentioned being objective. So at the end of that report, Matt, you wouldn't say, oh, after reviewing my facts and interviewing these witnesses, oh, I think this person's guilty as hell. Your opinion doesn't matter.
Not at all.
Not at all. So it doesn't belong in the report. They will show just the facts. Document what you saw, what you heard, what you felt through your five senses. And the better you document, the more likely of a successful prosecution. So it's so important that report writing be done properly, correctly. We're going to be meeting in, oh God, I think it's March. I forgot the date already. It's a career fair. And I'm inviting Chief Menifee's going to be there. Menifee PD, Chief of Police, Sheriff's Department, Border Patrol, you name it, they're going to be there. When we get together like this, we have our own panel. And I ask these leaders in our community that are hiring law enforcement, what's the one thing you want to see from my students? It's right there. Report writing. It's got to be good report writing. Number 2, soft skills. How to answer a phone. You don't be, yeah. No, but how to answer a phone. How to present yourself for work. Don't pull into the parking lot radio blasting and every other word's an F word, you know. Then you get out and you got those wife beater shirts and you're putting your uniform on, you think you're all, come on. They actually get these things or they wouldn't be telling me about it. Okay, so soft skills, report writing, critical. And if you think about it, even if you're destined to be in law enforcement, but you want a different career, it's just as important. It really is. Okay, so keep that in mind as we move forward through the rest of the semester. Okay, questions? Nothing about this week. This is it. Okay, but not guilty at the time of the crime. The other one was guilty at the time of trial. Completely, or excuse me, not guilty, mentally insane. Incapable of presenting a proper defense. Okay, 2 completely different standards. And remember, those are affirmative defenses. The responsibility is on the defendant, not the government. Okay? Matt, you got anything else you want to add?
Just one more quick note on report writing. I know it's a big
Yeah.
topic. Just to give you guys kind of an example, right? I put together a manslaughter case years back for a guy that actually ended up killing a deputy sheriff that was off duty. So he was intoxicated, drugs and alcohol. But I didn't stop at just the intoxication, right? Just to give you a little backstory, he was driving a BMW X Series, right, which he wrapped in Yas Marina Blue, right, which is an M Series color only, right? And I documented things like the tire size, the Z-rated tires because they're rated to go 186 plus miles an hour, right? Everything that went into this was documenting how he wanted his vehicle to go fast. He was doing 90 plus miles an hour 5 seconds before he ran a red light. Right? So everything that I documented was why he wanted to go fast, why he drove the way he did, not just that he was drinking at a party, not just that he used ecstasy, right? But everything else leading up to that, prior to and even after that, right? The interview that I had with him, how he was so proud of his driving behaviors and everything else. So everything goes into play in your report writing. That report was probably 25 pages long, right? Just the narrative, and it talks about everything you could think of. And I ended up getting a guilty verdict on that case because of the detail of that report. Had I just gone in and I said, yeah, he was drunk and he was high on ecstasy, the DA would have looked at it and they would have said, yeah, okay, but we're gonna offer him a lower sentence. I got the maximum sentence for that case, right? So it's very, very important to ensure that every detail you can have in there is in there.
Don't forget, what is that? The devil's in the details, right? The devil's in the details. Well, thank you. Thank you for coming down. I'm gonna go ahead and shut off the recording. Excuse me.